New Mexico Real Estate License Law and Real Estate Commission Rules. Page 16. 6. Client means a person who has entered into an express written agreement with a brokerage for real estate services subject to the jurisdiction of the commission. 7. Commission means the New Mexico Real Estate Commission. 8. Customer means a person who uses real estate services without entering into an express written agreement with the brokerage subject to the jurisdiction of the commission. 9. License means a qualifying broker's license or an associate broker's license issued by the commission. 10. Licensee means a person holding a valid qualifying broker's license or an associate broker's license subject to the jurisdiction of the commission. Nine. License means a qualifying broker's license or an associate broker's license issued by the commission. 10. Licensee means a person holding a valid qualifying broker's license or an associate broker's license subject to the jurisdiction of the commission. 11. Qualifying broker means a licensed real estate broker who has qualified a proprietorship, corporation, partnership, or association to do business as a real estate brokerage in the state of New Mexico, who discharges the responsibilities specific to a qualifying broker as defined by the commission, and who, for compensation or other consideration from another, A. lists, sells, or offers to sell real estate, buys or offers to buy real estate, or negotiates the purchase, sale, or exchange of real estate or options on real estate. B. is engaged in managing property for others. C. leases, rents, or auctions, or offers to lease, rent, or auction real estate. D. advertises or makes any representation as being engaged in the business of buying, selling, exchanging, renting, leasing, auctioning, or dealing with options on real estate for others as a whole or partial vocation. Or E. engages in the business of charging an advance fee or contracting for collection of a fee in connection with a contract under which the qualifying broker undertakes primarily to promote the sale of real estate through its listing in a publication issued primarily for the purpose or for the purpose of referral of information concerning real estate to other qualifying brokers or associate brokers. 12. Real estate means land, improvements, leaseholds, and other interests in real property that are less than a fee simple ownership interest, whether tangible or intangible. And page 17. 13. Transaction broker means a qualifying broker associate broker or brokerage that provides real estate services without entering into an agency relationship. B, single act of a person in performing or attempting to perform an activity described in paragraph 11 of subsection A of this section makes the person a qualifying broker. A single act of a person in performing or attempting to perform an activity described in paragraph 3 of subsection A of this section makes the person an associate broker. C, the provisions of Chapter 61, Article 29, NMSA 1978 do not apply to 1. A person who, as owner, performs any of the activities included in this section with reference to property owned by the person, except when the sale or offering for sale of the property constitutes a subdivision containing 100 or more parcels. 2. The employees of the owner or the employees of a qualifying broker acting on behalf of the owner with respect to the property owned, if the acts are performed in the regular course of or incident to the management of the property and the investments. 3. Isolated or sporadic transactions not exceeding 2 transactions annually in which a person acts as attorney in fact under a duly executed power of attorney delivered by an owner authorizing the person to finally consummate and to perform under any contract the sale, leasing, or exchange of real estate on behalf of the owner, and the owner or attorney in fact has not used a power of attorney for the purpose of evading the provisions of Chapter 61, Article 29, NMSA 1978. 4. Transactions in which a person acts as attorney in fact under a duly executed power of attorney delivered by an owner related to the attorney in fact within the 4th degree of consanguinity or closer, authorizing the person to finally consummate and to perform under any contract for the sale, leasing, or exchange of real estate on behalf of the owner. 5. The services rendered by an attorney at law in the performance of the attorney's duties as an attorney at law. 6. A person acting in the capacity of a receiver, trustee in bankruptcy, administrator, or executor. A person selling real estate pursuant to an order of any court or a trustee acting under a trust agreement, deed of trust or will, or the regular salaried employee of a trustee. 7. The activities of a salaried employee of a governmental agency acting within the scope of employment, or page 18. 8. Persons who deal exclusively in mineral leases or the sale or purchase of mineral rights or royalties in any case in which the fee to the land or the surface rights are in no way involved in the transaction. History 1978 Comp 61-29-2 enacted by laws 1999 CH 127 1 2003 CH 36 1 2005 CH 35 2 2011 CH 85 1 2013 CH 167 2. Statutory notes. Cross-reference. Tax credit. Certain conveyances of real property. 7-2A-8 period 9. NMS 8 1978. Prohibition 61-29-1 NMSA 1978. The 2005 amendment. Hold on. Cross-reference. Tax credit. Certain conveyances of real property. 7-2A- oh, maybe I did read that. The 2005 amendment, effective January 1st, 2006, rewrote paragraph A1, which formally defined both agency relationship and broker age relationship. Added paragraphs at A, 2, 3, 6, and 14. Redesignated former paragraphs A, 2 and A3 as present paragraphs. A4 and A5 redesignated former paragraphs. A4 through A10 as present paragraphs. A7 through A13 substituted qualifying broker for real estate broker throughout the section. In present paragraph A10 substituted an associate's broker's license for a real estate salesperson's license and changed the internal references in paragraph A13 and subsection B. The 2011 amendment, effective July 1st, 2011, added A4B, redesignated former A4B through A4D to A4C through A4E, substituted, makes a representation for, holds himself out in A4D, in C1, deleted or lessor, preceding, performs, deleted or leased, following, owned, and added, except when the sale or offering for sale of the property constitutes a subdivision containing 100 or more parcels, added the C2 designation in C2, deleted or lessor, following the owner twice, or leased, following property owned, and or the lease or offering for lease, following offering, sale, redesignated former C2 through C7 to C3 through C8. The 2013 amendment, effective June 14th, 2013, deleted to participate in an activity described in paragraph 4 of this subsection, or following a qualifying broker, in the introductory language of A3, deleted the former introductory language of A4, which read, Broker or qualifying broker means a person for compensation or other consideration from another. Redesignated former A4A through A4E, A5 through A11, and A14 as A3A through A3E, A4 through A10, and A13 in A3E. Deleted broker or following under which the and substituted other for brokers. Following real estate 2, substituted person for buyer, seller, landlord, or tenant in A6 and A8. Added A11, deleted former A13, substituted paragraph 11 for paragraph 4 in the first sentence of B. Deleted except when the sale or offering for sale of the property constitutes a subdivision containing 100 or more parcels at the end of C2 and made a related change. Editor's notes. Laws 2011, Chapter 30, 8. Approved April 2nd, 2011, and effective June 16th, 2011. Amended 61-29-19 NMSA 1978, which would have extended the sunset provisions of Chapter 61, Article 29, NMSA 1978 from July 1st, 2012 to July 1st, 2018. However, Laws 2011, Chapter 85, 11, approved April 6, 2011, and effective July 1st, 2011, repealed 61-29-19 NMSA 1978, C12-1-8 NMSA 1978. Judicial decisions, broker, investments, jurisdiction, lessor/owner, suspension, broker. Where a real estate broker purchased real estate, contacted a brokerage corporation to find a buyer for the contract, and then defaulted on the contract, the broker was not acting as a real estate broker. Therefore, suspension of his license by the Real Estate Commission was improper. V. Stite versus Real Estate Commission 106 NM 641-748 P. 2D 14 1988. Investments. A real estate license is not legally required in order to arrange investments in real estate contracts. Garcia versus New Mexico Real Estate Commission 108 NM 591-775 P. 2D 1308 CT APP 1989. Cert denied 108 NM 624 776 P. 2D 846 1989. Jurisdiction. New Mexico Real Estate Commission had jurisdiction over a complaint alleging that a real estate broker violated 61-29-12 NMSA 1978 in connection with the sale of a real estate contract because the broker was a real estate broker as defined in 61-29-2A NMSA 1978. He represented himself as such and acted in the capacity. The contract itself indicated that the broker was being employed in a broker's capacity, and he received a commission for the transaction. Elliott versus